Welcome to this unidentified channel. Before we get into the video, I'd like to ask you, do you have any ideas on a name for this channel? Do you have any ideas on a background? I'm looking for ideas. I'd like to make a decision very soon, so any ideas you have, please leave them in the comments. If you haven't already, hit that subscribe button, and if you like the video, hit the like. I appreciate all of your comments, all of your likes, all of your dislikes, and all of your support. I'd like to know where you're watching from. Are you in the United States? Are you in another country? Let us know where you're watching from. I am sitting in Middle Tennessee. Now, let's dive right in. Today, we're talking about Melani and Ian Pawlowski. Have you seen the new court documents that came out? The documents go over some of the things that are going to be happening over the next couple of weeks. I believe their next custody court date is November the 19th. Before November the 19th, some things have to happen. This court document was posted by Justin Lom on his Facebook. I printed it out and read through it, and we're going to go through it now. At the top, it says, Superior Court of Arizona, Maricopa County. The document goes through scope, timely written report, initial contact, authority of evaluator, and it goes on to no ex parte contact, fees, evidence, testimony, and immunity. So, going through the scope, it talks about what the evaluator can do. So I'm just going to read through this paragraph with you. If you've already heard it, just bear with me. Comprehensive family evaluations typically involve 20+ hours of professional services. CFEs investigate long-standing and broadly based issues of family functioning and parenting capacity. Parents and children are interviewed more than once. Psychological testing is often administered. Parent-child relationships are examined in greater detail than in a limited family assessment. Documents submitted by attorneys are accepted for review, usually without screening by the evaluator. More collateral witnesses are typically contacted than in a family assessment and may be interviewed in the office. The report will likely be lengthier than in a family assessment and provide a narrative of the family's historical context, parent-child dynamics, assessment of parenting capacity, assessment of child's developmental needs, and a full range of recommendations addressing legal decision-making, a detailed parenting time schedule, and recommended therapeutic interventions, sometimes including treatment goals. The issues to be addressed are fitness of both parents and legal decision-making recommendations. That's the scope. So what it's talking about is they're going to talk to friends, family, anybody associated with this family. It goes through that nothing is off limits and they have access to everything. It is very detailed, very in-depth, more than 20 hours. Now, I don't know if that's 20 hours in both homes or 20 hours combined. I guess we'll see that once the report comes out. Number 2 is a timely written report. The court is asking for a detailed written report be submitted to the court by November the 9th. It needs to be delivered to counsel. Everybody has access, and it'll be very detailed, pretty much. And number 3 is initial contact. This just talks about how the evaluator will be set up. They have 10 days from October the 8th to get this set up. It'll be set up on a conference call where both Melani and Brandon or their counsel is on the call to talk with this evaluator and get everything set up. 4, authority of evaluator, cooperation by parties, waiver of confidentiality. Like I say, they have access to everything. So medical records, school records, any kind of psychological reports or therapist. Here are some of the bullet points in number 4. The evaluator will serve as the expert for the court. in order to provide data and opinions relevant to the care of legal decision making and parenting time with the minor child. They'll have access to therapists for the children and the parents. They'll have access to school records and medical records for both children and parents. Any and all psychological testing or evaluations performed for both children and parents. I'm assuming Ian is part of this just because he is now in the family. They will have access to any teachers or child care providers that have cared for the children. Any kind of social workers that has any information, they'll go outside and talk to family and friends, neighbors, mailman, anybody that is associated, they can reach out to get information from. Number 5 is no ex parte contact. Counsel shall not have substantive ex parte discussions with the evaluator, but shall conduct all communication through conference calls or conferences. So Brandon can't be like, hey, evaluator, I want to talk to you, and then he'll discuss something without Melani being in that discussion. That's what I'm gathering from that. It says copies of any documentation provided by counsel or the parties to the evaluator shall concurrently be sent by the providing person to the other side. So everybody has access to everything. Number 6 is fees. Everything's 50-50 unless, right? So Brandon pays 50%, Melani pays 50%, and then if a meeting or a time is set up and either Brandon or Melani don't show, then they would be responsible for the fee of that meeting that they didn't show up to. After the evaluator types up their document and submits it to court, if Melani would like the evaluator to be in person in court, in addition to the document, she would be responsible for paying that fee at 100%. If Brandon wanted the person in court, then he would be responsible for paying the fee for that at 100%. Number 7 is evidence. That's the written report the evaluator is going to turn into the court. Anything in the document cannot be called hearsay during the court hearing. Like if it's in the document, it's fact, and no objection hearsay can apply. Testimony, that just goes through what I just told you. If they want the evaluator in person in court, they would have to pay that fee 100%. Number 9 is immunity. Services provided under this appointment order will have quasi-judicial immunity to the extent it is afforded under the law. I'm not sure what that means. If you know, let me know. That's the extent of the document. We will have some sort of written document submitted to the court by the 9th of November, and then the court hearing will be on the 19th of November. As I was gathering my information and doing all my research, I found a comment that stated she was able to call in and listen to the court hearing. It's not recorded, and after the hearing is over, you can't go back and listen to it. So I can't call in today and listen to the court hearing. It's over. You have to be on the call live while it's happening. There was also no video happening in the court. However, based on what this commenter said, the judge would allow video in the courtroom for the custody hearing. If you're media, if you can get into the courtroom with a camera, please go video the hearing for us so we can all see it. We all want to know what's going on with these Boudreaux kids, with Brandon, with Melani. Let us see what's happening. If you have any other information about this document, about Brandon Boudreaux, about Melani Pawlowski and the kids, put it in the comments. I wasn't able to find a lot, but I was able to find out these few things. Other breaking news. Have you heard the news? One of my first videos was about, is Melani pregnant? We saw her in May do the interview with Nate Eaton. She didn't look pregnant. She didn't tell us she was pregnant. We found a document stating that Melani remarried and had married Ian, and that she was now pregnant by her new husband. That's all the information we had, and I was able to find out Melani's not pregnant. Did you know that? She's not pregnant because she had the baby. They had a bouncing baby boy sometime in September, from what I can find. I found a comment by someone who claims to be their current neighbor. They are currently living in Mesa, Arizona, and this person stated he was shocked to find out that Melani and Ian was his neighbor, and that he had saw them with the baby, and that she had the baby about 6 weeks ago. I don't know what hospital they were in, how much he weighed, what his birth date is, or his length, but since no information is out, we can only assume that mom and baby are doing well. Congratulations to Ian and Melani on their brand new baby boy. If you know any details about the new baby, please let us know. Do you know his name? As I was doing some research, I found Melani on Facebook, and I thought I would send her a quick message. I pulled up my Facebook Messenger, and I did just type her a little message letting her know that there was lots of speculation going on, and since she is the one we're talking about, if I could get the information directly from her, then we know it was true. She hasn't replied. I don't expect her to reply, but if she does reply, I will definitely let you know. That's all I got for you today. Thank you so much for watching, and I'll see you next time. That's all we had, so that's all we had to go on. No. Counsel shall not have substantive. If this commenter said the judge Melani and Ian had a bouncing baby boy. See my sign? I did some research. Oh yeah, I did.